So hello and welcome everybody. My name is Patty Murray and I will be your host and moderator for today's peer-to-peer webinar presented by FamilyKind, a nonprofit organization that empowers children, parents, and couples before, during, and after separation or divorce. We are able to bring you this webinar series for professionals free of charge because of the generosity of two of our sponsors, SoberLink and Our Family Wizard. SoberLink supports accountability for sobriety and child safety, combining a breathalyzer with facial recognition and wireless connectivity for real-time results and reports. SoberLink's new Family Assistance Program offers alcohol monitoring free of charge to anyone who qualifies. By increasing our total reach in our mission of supporting families affected by alcohol abuse, this program will help continue to reduce litigation and foster peace of mind. Our Family Wizard is a comprehensive app that enables you to conduct all co-parenting communication on a single platform. Powerful tools document your parenting time, reimbursement requests, payments, exchanges, and more. This means less conflict and more energy to focus on your children. So what I'd like to do right now is, is to introduce our speakers. Today's webinar is entitled Co Mediation, Are Two Heads Better Than One? We are going to learn from two professionals who are partners and co-founders of Hudson Mediation Group, a co-mediation practice serving Westchester County in New York City. Helise Harrington is an attorney who has practiced as a family mediator and conflict resolution coach since 2010. Earlier in her career, Helise spent over 20 years negotiating business agreements for companies, including multinational corporations and family businesses. Helise is a divorce and family mediator for FamilyKind, as well as divorce mediation professionals. She has a JD from New York University of Law, an MA from Columbia, and a BA from Stanford. Bess Steiger is a licensed clinical social worker who has been a divorce and family mediator since 2003. For FamilyKind, she provides divorce mediation, parent coordination, and divorce coaching services. Bess also is a therapist in private practice and a community social worker, helping seniors and families navigate decision-making around healthcare, end of life, and bereavement. Bess received her master's from CUNY Hunter School of Social Work and her BA from Leeds University, UK. Also joining us are Leslie Friedland, Executive Director of FamilyKind, who will add her insights in from time to time. One housekeeping note, please feel free to send your questions using the chat feature, and we will address your questions during a special Q&A session at the end. So with that, it is now my pleasure to turn things over to Bess and Helise.
Thank you, Patty, for your kind introduction, and thanks to both Patty and to Leslie for this opportunity and for all of you who are with us today. When I went to law school back in the Stone Ages, there were no courses on mediation. And in fact, I don't remember it being discussed in any courses I took except a brief mention of the New York City subway strike. It was really only when I became a practicing attorney that I learned much about mediation and became entranced by it. Initially, I trained in commercial mediation and did some work through the courts. I did see that having a neutral in the room was helpful, but for me, commercial mediation was a bit disappointing. The voices in the room were still primarily those of attorneys, and the neutral's job was that of shuttle diplomacy between groups of attorneys. The type of mediation that appealed to me was one in which the parties were better empowered and the neutral's role was to assist them reach a mutually agreeable solution. So eventually I hung up my spurs as a corporate attorney and entered the magical world of family mediation. I chose co-mediation really because of happenstance. At that time, Bess and I were both volunteer co-facilitators at a not-for-profit that helped surviving members of families in which a parent or child had recently died. We discovered we were both interested in mediation, Bess was a dynamite facilitator, and we both thought that a social worker and a lawyer combination could be magical. Before we talk about the pros and cons we discovered in co-mediation, Bess will say a few words about her very different path to family mediation.
Thank you, Helise, and thanks again to Patty, Leslie, and FamilyKind. I came to mediation from my interest in issues related to Israel-Palestine. I'm a firm believer, even now, in the need for and the power of dialogue. I trained initially in community mediation and restorative justice with the Westchester Mediation Center Cluster. They organized their restorative justice program using co-mediators. In Helise, I found a kindred spirit, as well as a most skillful attorney and mediator. We founded our practice, Hudson Mediation Group, in 2010. We chose that name partly because we lived in the river towns along the Hudson, but also because the Hudson River has currents that flow both ways, similar to the process of mediation. Our initial focus was working with intergenerational families to help them have challenging conversations to avoid or resolve conflicts. Our motto is moving families forward. We believe that family mediation can be transformative and lead to meaningful change. Co-mediation is desirable in facilitating multi-party mediation, and Helise will address more later. We added divorce mediation as a service to be able to reach more clients and expand our practice. We like working together and see co-mediation in divorce and separation as an asset to the process. And we are pleased that it has led to our connection with FamilyKind. So what are the benefits of co-mediation? We'd like to discuss what we see as the benefits and some of the disadvantages for mediators, and talk about the benefits and disadvantages of co-mediation for the parties, and then we'll look at 2 real-life case studies. Helise?
An important way mediators benefit from co-mediation is in their professional development. We all participate in peer meetings and conferences, and the online mediation community is an important source of information. But what one additionally gets from co-mediation is a continuous mediation clinic. We are in the room together, and after each mediation, we make a habit of scheduling some time to go over what happened, including what we think each of us did well and what didn't work out so well. In thinking back over our 10 years of co-mediation, and maybe perhaps the most helpful feedback that I received was how I handled silence. What I used to do all the time, and what I still do occasionally when there is silence, is to jump in and suggest ideas and possible paths the parties could take, when often not saying anything, no matter how antsy I get, is the better solution. I like to think of myself as self-reflective, but like most of us, I have my blind spots, and having another see me at work has helped me become a better mediator. Another benefit of having a second voice in the room, particularly a professional with a slightly different perspective, is that it's a good check to make sure that both of us understand the parties, the information that we get from the parties correctly, and that we are exploring all issues sufficiently. In addition, the ability of co-mediators to observe and brainstorm provides the opportunity for greater creativity and more risk-taking, and I think our role modeling can be of help in breaking impasses between the parties. We do think that co-mediation is particularly helpful in difficult mediations. 2 mediators bring more resources and control to mediation. If a party is beginning to trigger one of us, the other can step in. It's easier to keep the mediation on track. I can think of one mediation in particular that I did on my own. The parties had already been through one mediator, and both seemed capable only of hurling insults and complaints at each other, and my interventions were not particularly helpful. I eventually had to terminate the termination. I'm not saying that co-mediation would have saved the day, but I actually think it might have, and it certainly would have been helpful. In many of the multi-family mediations we do, having more than one mediator is critical. The case study I will talk about in a bit involves 7 parties. Just keeping all the different issues and viewpoints in mind was a challenge. And most of these mediations are highly fraught. Families seem not to want to air their family's dirty laundry, I understand that, and don't agree to mediation unless their problems are difficult and nothing else has seemed to work. In addition, there is no legal guide or no clearly endpoint to aim for in the mediation, such as there is in divorce mediation where you have a separation agreement, so that it is really helpful to make sure that everyone in the room is heard, and it improves the likelihood of success as defined by the parties involved. Another benefit for those of you who caucus, we rarely do, but each of you can be with one of the parties, and it avoids dead time for either party, and it likely speeds up resolution. At time, there's the element of safety. Not being alone in the office with volatile parties can be comforting. And last of all, it's fun to mediation. It mitigates the loneliness of what is, in effect, a solitary practice, and it certainly has enriched Bess and my friendship.
So there are some potential disadvantages that relate to all mediators doing co-mediation, and some that relate specifically to the kind of practice we do at Hudson Mediation Group. The first issue is probably the most obvious, that of interrupting each other or stepping on each other's toes. How can you get the attention of your co-mediator when you want to interject, or when you think the conversation may be going in a direction that you or the parties don't wish to go? This is particularly difficult now doing mediations remotely, as you can't kick your partner under the table. Some of these challenges can be worked out by careful planning ahead, as well as discussing how things go between sessions. And plus, over time, you do learn to balance and adjust to each other's styles. As Helise mentioned, I may be more comfortable with silence, but Helise is excellent at keeping clients on target and moving the process forward. When I was doing restorative justice conferencing, the agency threw you in with a co-mediator without any preparation beforehand, and that led to some difficulties and certainly some very challenging and frustrating moments. So what is important to remember, though, in this is that you are role modeling for the parties how to allow each other time and space to speak, and how to talk and even disagree respectfully. To us, this is invaluable, especially with clients who are in high conflict. In our particular circumstance, as an attorney social worker team, we face the issue of attorney-client confidentiality versus being a mandated reporter. We will talk in a few minutes about how this played out in one of our cases, but this is clearly an important issue to be addressed, and how or if you are going to let your clients know about the parties, the possibility of reporting. At Hudson Mediation Group, we do not charge extra for clients meeting with both of us. FamilyKind as well does not charge for meeting with 2 professionals rather than 1. We chose to do this so that we could reach out to clients of more limited financial means, but it does mean there's less remuneration per professional. What about for the parties? What are some of the advantages of co-mediation to them? Well, having 2 people in the room allows for more viewpoints, which adds to and expands the conversation. It's often hard to view an issue or problem from different vantage points when you're in the middle, especially if the issue is contentious. Having the input of the second mediator may help parties think outside of the box and get unstuck. Co-mediators bring a mix of professional perspectives and experience. Helise has a great understanding of and comfort level with financials and legal matters, and I may be more at ease with emotional or mental health matters, for example, but of course there can be a variety of different types of professional perspectives that your co-mediation practice may involve. Having 4 people in the room also creates a better balance than 3 and avoids triangulation. What I mean by triangulation is the tendency when there's 3 people for 2 people to ally together and leaving the 3rd person out in the cold. For the parties too, they can feel that having 2 professionals ensures that all issues are covered and that all the information necessary is gathered. So there are some disadvantages of co-mediation for the parties as well, which Helise will address.
Bess and I offer professional diversity. Although Bess likes to point out that she's the younger of the 2 of us, it does seem clear that we are both mediators of a certain age. We also are both women and with the same racial background. I have often wondered in particular how a man in a divorce mediation feels with 3 other women in the room. And with clients of color, it would likely be more comfortable if we were not both white. Our professional backgrounds are not always a plus. They sometimes create confusion. We always emphasize that we are both trained mediators, that our professional background is really just to help and not the primary element. But sometimes people seem a bit put off when Bess starts talking about child support guidelines, or I start showing concern about an emotional impact of an event. And then there has been actual fear about our background. In one mediation, Bess voiced concern about the obvious depression of one of our clients, and the response was, back off, we're not in therapy. In intergenerational mediation, distrust of lawyers, I don't get it, but distrust of lawyers often comes to the fore. Another disadvantage is that there is greater complexity of the number of communications in the room, and at times there can be disagreements that come up between the mediators. In a confession, when we first started mediating, we decided that we didn't want to decide who was going to do what roles, and we did end up having an issue with scheduling. A few times we both communicated with clients about what was happening next, and one time we assumed the other was doing it and nobody communicated. So we had to concentrate and come up with roles, and then added a soupçon of newfangled technology, and that seemed to be solved. Although charging more for co-mediation makes sense when there are more than one, obviously more than one mediator, and sometimes it's expected in multi-party mediations, additional costs can be an issue that scares folks away. But before time gets away with us, we would like to talk a little bit about 2 co-mediation cases that we handled.
Thank you. This is a case where the issue of client confidentiality versus mandated reporting came up. It was a case that was referred to mediation by a judge. The parents had joint custody, but the mother wanted to relocate out of state with their 13-year-old child and needed the father's permission. The father did not want the child taken out of school mid-semester. but both parents did agree to mediation. The issue related to the child's history of suicide attempts and self-harm behavior. The mother stated that the child exhibited a lot of stress before or after being with the father. However, the father stated that the child was happy with him, and he did not see the child at any psychological risk. He also did not want to put away the instruments that the child could potentially use for self-harm. This was a red flag for me as a social worker, and certainly a cause for sweating for both of us. If the child were to stay with the father for the remainder of the semester at least, could he or she be at risk of self-harm or even suicide? What we were able to work out with the parties in mediation was that we got their agreement for us to contact the child's psychiatrist, and the psychiatrist agreed that the child would do well to stay with the mother and that the relocation was a good idea. The father then agreed to follow recommendations and allow the relocation. He also agreed to put away the instruments for potential self-harm for when the child would visit him. And the mother was able to connect with a psychiatrist in the new location and had an appointment already set up for the child for follow-up. So in the end, we did feel that there was a good plan, and a plan that definitely took into consideration the safety of the child, and as much as one can ever guarantee that. So we did not see the need or benefit to reporting for Child Protective Services. But as you can see, it was definitely an issue that needed to be discussed, that Helise and I talked about during the mediation process as well.
The second case study, as you can see, it was a blended family. The family agreed to meet in mediation to discuss their long-held upsets, because it was clear to almost all of them that their anger and hurt at this point made it impossible for them ever to get together. And most of them were not speaking to at least a few of the other members of the family, and all were suffering a feeling of loss and isolation. We don't have time to discuss all of the issues the seven of them raised, but they involved the feeling by each of them that their difficulties were not acknowledged by the rest of the family. Some of the issues involved the marriage itself, which had occurred soon after the death of the husband's first wife, while his kids were still in mourning. And there was never any talk in the family about how difficult it had been for all of them to adjust to the new family composition and their changing roles. The husband's discipline of the stepdaughter was also an issue. It was sufficiently abusive that CPS became involved, and the stepdaughter still felt that the family blamed her for the intervention and let the husband off the hook. Other problems were a sharp disagreement about how family property should be distributed, and the addiction of one family member that was a secret from half of the family. On top of all of this, the husband thought the idea of mediation was nonsense. He initially said he would come and say nothing. His silence lasted about a minute, and he became disruptive, interrupting everyone and belittling what they had to say. Since many of the parties had traveled from a long distance to get to the mediation, they decided that a one-day, incredibly long session would be what they would do. At the end of 5 hours, all of us were exhausted, but everyone except the father felt that they had all gained something important from the mediation. Most of them acknowledged the depth of others' difficulties, which in itself seemed to ease the tension between them. Well, certainly not everything was resolved, To our delight, the adult children decided they wanted to meet again. And a month later, we did hear that the daughters did in fact meet and were planning to do so again. The mediation we felt, and most of the family felt, appeared to be a success. So that was one of our multi-party mediations.
So thank you so much, Bess and Helise, for all that, your presentations and insights into your practice. Before we start to take some questions from the attendees, and I'll remind everybody to keep sending in your questions using the chat feature. I'd like to invite Leslie Friedland, the Executive Director of FamilyKind, to say a few words.
Oh, thanks, Patty. And thank you, Bess and Helise. You know, we've been preparing this, and I'm just so really admire the practice that you both have, and really seeing the value of this co-mediation model, and you know, the fact that you just do it at the same rate. And thanks for going over everything. I'm just wondering, in this model, since you do bring two different professional perspectives, do you ever find the need to even bring in a third specialist? Like, I know in child inclusive mediation, sometimes, you know, a child specialist is brought on, or sometimes the financial issues are so difficult, a financial expert might be brought in. Do you feel that with you two professionals at the table that there's less of a need for that?
As far as a financial expert, what we have done is we have recommended some financial experts, and the parties have seen them separately. Maybe Bess would be better answering about the child.
We have not brought in you know, say a child specialist into the room with us, but we have definitely, again, with the parent's permission, reached out to those professionals to discuss a case over the, you know, over the phone. But we would not, you know, that could certainly take place in the future.
Mm-hmm, mm-hmm.
Maybe we'll have to, one thing we might have to do is get a bigger room.
Right. Now with Zoom, I guess, you know, there are spots for a lot of people, but I don't know.
Yeah.
And just to dovetail on that comment, that with our family mediators, we do offer to go to people's homes. And certainly in this case that Helise described, you know, we really had to do that. There were, you know, you would need an enormous auditorium practically to fit everybody. So, and it just geographically made sense and was more, and often it's more comfortable for the parties.
Oh, so could you expand on that a little bit? You do go to people's homes?
Yes, yeah. Especially we've done some cases where we've had frail elderly. And so to take them out of the home would be both just physically difficult. It also may you know, contribute to greater confusion, and makes it more likely that they'll agree to mediate.
A number of our family mediations have involved who takes care of an aged relative. Mm-hmm. Also, there was one that was very fascinating where the older member was involved, and he felt very strongly that his two daughters were not respecting his autonomy. Mm-hmm. And they felt he wasn't careful enough. And that was at a home. So we also had a case where someone was dying, and that he was at home and his family was around him, and that seemed like an obvious place to meet. So with divorce mediation, it's rare, if ever, but for the family mediations, yes, we do go, we travel.
Very good.
So thank you for that. And I wanted to just let people know that we're closing in at 1:30, but we had a feeling this would go a little longer. So we're going to address the questions that are coming in from the attendees. So feel free to hang out a little bit longer. If you have to leave, we understand. We will send out the archive so you can review the answers at that point. We have somebody asking, when you work as a team with with both parties. Do you find that maybe one party aligns with one of you individually over the other, or is it they connect with both of you equally?
That has happened. And I think one of the things that's kind of important is who you look at. Like, not always to look at the person who's speaking, but often turn to the other party so that they get a sense that, you know, we are in this together and that we're kind of a foursome, you know, not just not making two by two alliances. So, and kind of bringing that person kind of back to the table, or allowing then that other mediator to step in if you're kind of feel like one party is turning to you, then, you know, kind of trying to bring in that other mediator. So you can, again, avoid those kind of alliances being formed.
Okay. And you had mentioned earlier in your presentation that you can sometimes step on each other's toes. Other than kicking somebody under the table, how do you work with that?
We aren't perfect, and we do sometimes. We've worked together for 10 years now, so we can tell a lot by the other's facial expression. Oops. And we do talk afterwards, so that, you know, if it does happen, we try not to have it happen again. So Bess, I don't know if you want to add anything to that.
Yeah, again, it is helpful to have worked together with each other for a while to figure that out. But, you know, some people like even do a little look or a little hand movement. But I think it's okay to sometimes interrupt you're showing and stop yourself and move on, because it just showed that to the parties that you can do that respectfully and maybe even laugh about it.
And
yeah, we try to be respectful. We never curse each other out after one of us steps on the other's toes.
And we have somebody asking, how would you distinguish the co-mediation process from the co-counseling process, where the goal is to resolve conflict?
From co-counseling? So, well, again, in terms of the difference between mediation and co-counseling, I think the two terms are often misunderstood for their being very distinct. Again, mediation is more of a problem-solving model where you're really working on a particular issue or set of issues that, you know, that the parties want to address. Whereas counseling may be more, you know, looking at past relationships, moving forward to future relationships and future problems that don't exist in the immediate moment that you're mediating.
And then we have somebody asking about caucusing, which you had mentioned earlier in the presentation. It's unfamiliar to them, and they're wondering, are there any risks to neutrality or impartiality when you're caucusing?
I think there are, maybe less. You know, I've done a little caucusing, Bess has too, and we've done, I think, only once together. If you're meeting with, if you have several caucuses and you alternate attorneys, I think that lessens the concern that one of you is taking one person's side and the other's taking the other. I do feel that is a problem, and that's something that I think we both try not to do too much of, because I do think there is a danger that there is a feeling, that person is not the person who doesn't caucus is feeling that, hey, that person is on his side, not my side. So I do think that is potentially a problem.
And then you touched on this, but if you wanted to expand on it in any way, we have somebody asking, what are your thoughts about the option of having one male and one female co-mediator when you have at least one male and one female stakeholder?
It's, you know, if you're starting a co-mediation, it's certainly it's one way to go. when you have if you have two lawyers, one man, one woman, you're giving up professional diversity. So I mean, there are a lot of different ways you can handle this. I don't think we would pop a man in instead of me or Bess, just because we've done it for so long together that it's sort of like a poodle you own for a while. I mean, we know how to respond. We're beginning to look alike. The whole business of having done it for a long time is very important. But that's an idea as far as if you're starting a co-mediation practice. Another is having people from different backgrounds. That would also be a good idea.
And then how much do you plan ahead for a mediation?
How do we plan ahead for mediation?
Yeah, how much do you plan ahead? So I'm thinking, you know, in maybe time and then types of activities that you do when you're planning for the mediation.
It's hard to say, you know, exactly in terms of time because it really can vary. You know, we'll have our initial conversation about how in meeting with the client for the first time, who's going to introduce what. And then again, we'll review how that went after the mediation and you know, to plan for the next session, whether we sort of decide to trade off or focus on one particular thing. So, you know, it's variable in terms of time. It doesn't usually take that much time. Again, part of that is because we've worked together for a while. So
we also have consultations that if we can, we do it together. Sometimes we do it apart. And before consultation, if either party wants to talk briefly on the telephone, we will do that. We get some information from that, and that adds to our preparation.
Okay. And do you find that a lot of attorneys participate in co-mediation, and the person is asking specifically about AFCs?
Okay, AFC?
Yeah.
Okay. As far as, you mean, do they mean there are many co-mediators who are attorneys? Is that what they're saying, or that are in our mediations?
I'm not sure. I'll ask her to restate the question, and then we can come back to it. Do you find that people are often receptive to the two mediators versus one? I would guess so, because that's people are coming to you. They would probably know that in advance.
Yes, and we also give them a choice if they, you know, stumble into us, and they really would prefer not to have two. We will accede to their wishes. But generally, people, yes, are happy to have two.
Okay.
Particularly since we don't charge more.
We have somebody asking, do you ask for a pre-mediation memo?
No, we do not. I mean, that brings back memories, because in commercial mediation, you always ask for a memo of all the, we do not. We like to get some information about the family, about the issues, but we do not ask for a memo. The one time we had it was it was a pre-litigation, and it was a matter of an estate. And we did have people write down what was involved, as far as they were concerned, what was involved, and that was helpful, but we generally do not.
Okay. We're going to keep on with the questions, but I just wanted to let people know that here are some resources about co-mediation that our presenters have put together today, and we will post on the website a PDF of today's slides so that you can get these resources, or if you want to do a screenshot, feel free. So the person with the question gave us a little bit more information. I was asking about attorneys for the parties participating in the mediation and whether attorneys for children are ever welcome, or if they ever come.
If the parties do request an attorney in the room, we'll be open to it. Since attorneys have a tendency to take things over, we prefer not, but we will be open to it. We also will have translators if someone doesn't speak well, or other people who would be helpful. So we have worked with attorneys in the room. We certainly work with consulting attorneys and review attorneys.
And I just want to add that our next webinar next month, our professionals, Helene Bernstein and Andrea Hirschman, are going to talk, among other things, about mediating with attorneys in the room, since the court model seems to be have that built in. So that's something that some mediators will be new to them.
And we'll certainly be interested.
Just a little bit more on obtaining pre-mediation information. Obviously, you talk with them on the phone. Do you email them like intake forms or anything like that?
Yes, there is some specific information. They're they aren't very lengthy at all. But if they're living together apart, the number of children, do they have? This is basically on divorce mediation. But children, do they own property? What they think are the particular difficulties that they may want to talk about, and this sort of thing. It doesn't take very long. It's harder with family mediations, and there we don't have a form. We will hear from someone. There'll be one person probably in particular who's interested in it, and so we may send an email out to everyone with a request to give us a few more salient, a little more salient information about the possible mediation.
Okay, we still have a couple more questions, but I wanted to, we had a question also actually about some of the elder care and end-of-life work that you do. Do you often have medical professionals participate in that, as well as when you're talking about end-of-life issues, does a hospital or a facility ever send a representative from their ethics committee?
So it has proved to be challenging to get hospitals or other formal organizations and institutions to want to use an outside mediator. So they think that their own case managers or social workers, etc., can handle these kinds of cases. We don't really agree, because we feel that those professionals represent the agency and don't have the neutrality and the independence that an outside mediator would. So at the moment, those kinds of relationships would be more consultative. We have not, as they say, we have not had a hospital request in ethics. And I doubt that they would, because ethics professionals usually only handle in-house cases.
As far as when we were starting out, we went to talk to some nursing homes about this great service we could provide them. And I've never seen such horrified looks on people's faces. Oh my God, having outsiders come in. So I mean, there are some hiccups here and there.
Okay. So we've covered a lot of ground, and we had a lot of great questions. I think I got to everybody's question. If I missed it, I do apologize. But what I'd like to do is ask each of you, since we covered so much ground, if you had one key takeaway about co-mediation, what would it be? So Bess, why don't you start?
Sure, thank you. I think that co-mediation provides a wonderful way of expanding the the services you can offer, expanding your practice, and ultimately it is very professionally satisfying and fun.
Great. Helise?
And even if you don't decide to have a permanent co-mediator with you, which can be fun because you really get to know the person, but if it's a particularly difficult mediation, or if you get a mediation where there are a lot of people involved, it's good to have that as a possibility on tap for you. Some people that you feel very comfortable, that you know very well, and perhaps have had a little practice doing some co-mediation.
And Leslie, do you have any final words? Oh, you're muted, Leslie.
Thank you to our panelists and Patty, and to all of you professionals joining us. It was a great way to spend some time, and Helise and Bess, thanks for sharing all of that.
Thank you.
And I want to thank everybody too, and thank you to the attendees for sending in such great questions. I also want to thank our sponsors again, SoberLink and Our Family Wizard. Without them, we would not be able to put these webinars on, so thank you so much for your support. As Leslie mentioned, our next peer-to-peer webinar will be on August 17th. We also have another webinar series going that's for families, and it's called Coping with Co-Parenting, and that's on the first Monday of every month at 8 p.m. Eastern. And so our next one is on August 3rd. And that's a part 2 on how to have important conversations with your family about Black Lives Matter. And as always, feel free to look at our website, FamilyKind.org, for more information about our services and other activities that we have going on. And of course, we are 501c3, so we are able to put on these programs with the help of our sponsors, as I mentioned, but also through donations from families and professionals such as yourself. So feel free to check out our page that is help-FamilyKind on our website. Thank you, everybody. Have a great day. We'll see you next month.
Thank you.
Thank you.
Thanks, everyone. Thank you, Patty. Take care.